Supreme Court of India Ramvir Saket Singh vs State of Madhya Pradesh decided on April 16, 2024 SEC Online SC 542 Facts of the case. The appellant was tried for the murders of Captain Singh and Kalyan Singh and for the attempted murder of Indul Singh. Trial court convicted and sentenced the appellant under Section 302 for the murder of Captain Singh and 307 IPC for the attempted murder of Indul Singh. However, trial court acquitted the accused appellant from the charge of murder of Kalyan Singh. High Court dismissed the appeal. Findings of the court: that there is no dispute on the aspect that the incident wherein Captain Singh was killed took place in front of the house of Captain Singh. The prosecution has come up with a clear case that when Indul Singh, prosecution witness 12, saw the assailants, i.e., the appellant herein and his two companions, Shatalu Urf Ram Mohan and Shiv Singh, firing towards deceased Captain Singh, Ramraj Singh, prosecution witness 14, and his camel, Indul Singh, prosecution witness 12, used his licensed weapons to fire at the assailants in self-defense and in defense of Ramraj Singh, prosecution witness 14, and Captain Singh. The gunshots fired by Ramraj Singh, prosecution witness 14, and Indul Singh, prosecution witness 12, resulted into the death of Shatalu Urf Ram Mohan and Shiv Singh. The evidence of Indul Singh, prosecution witness 12, and Raj Kumari, prosecution witness 7, is categoric on the aspect that the gunshots fired by accused appellant herein struck deceased Captain Singh on his stomach and chest, etc. Indul Singh, prosecution witness 12, has come out with a clear case in his examination in chief, explaining the manner in which Shatalu Urf Ram Mohan and Shiv Singh received fatal gunshot injuries. His testimony could not be impeached despite extensive cross-examination. The allegation made by Indul Singh, prosecution witness 12, regarding the accused appellant having fired gunshots at Captain Singh is duly corroborated by presence of gunshot injuries on his body as deposed by the medical jurist Dr. Rakesh Sharma, prosecution witness 11. The contention advanced by learned counsel for the appellant that these witnesses are partisan witnesses as being closely related to the deceased and hence their evidence should be discarded, does not for a moment convince us, because in a case involving gruesome broad daylight double murder by repeated gun firing, it is unlikely that any of the persons from the neighborhood would have the courage to step forward as witnesses. The trivial contradictions sought to be highlighted by learned senior counsel for the appellant regarding absence of empty cartridges etc. At the place of incident and the plea of alibi is not tenable because we find that these contradictions are far too trivial so as to discard the entire prosecution case, which is based on reliable and trustworthy set of eyewitnesses whose evidence is corroborated by the evidence of the medical jurist and other attending circumstances. Resultantly, the appeal lacks merit and is dismissed as such.